Good afternoon and welcome to AM News Network presents Summary Judgment, transmitting live from the American News Media Center in Harwinton, Connecticut, or from Central Connecticut, our new location. I'm attorney Rachel Beard, and seated to my left is Ed Peruta. Ed, what else could we possibly discuss today but the incident in Minneapolis and George Floyd?
Master Control has a graphic. Put it up. That's the topic we're starting out with.
Qualified immunity and George Floyd. How many of you have watched the show in the past 3 or 4 weeks when I've attempted to talk about qualified immunity? I guess there was a reason that I didn't talk about it.
Now there's a reason.
Because now there is a reason, and on this show, in the next hour, we're going to connect the inadequacy of the courts, qualified immunity, as the direct, proximate causes of the death of George Floyd and other incidents like that. And do you know what qualified immunity is?
Yes.
Supposedly, in the United States, there's a civil rights statute, 42 United States Code 1983.
Correct.
That allows damages when your constitutional rights are violated by police officers and other government officials. But we're going to talk about police officers today. But why is it that in many, many cases, I'm going to say a substantial or majority of cases, police officers are allowed to have qualified immunity to avoid responsibility for incidents like happened with George Floyd, for excessive force cases, for searches that are illegal, and a variety of other things that violates people's constitutional rights, including violating a journalist's First Amendment rights. Why is it that police officers, despite the fact that we have a civil rights statute, violate people's constitutional rights and remain not liable in federal court and state courts for that conduct?
You asking me?
I'm asking you. 2 words.
Let's assume that a government, we'll call the government employees government actors. Summary judgment. I did. Hello. You're on. Listen, there is a delay that you're going to have to. Go ahead. Okay. Shut off your computer or turn the volume down.
I just did.
There's a delay between what we say and what goes out over the internet. Your name is Jerry.
Okay, that should clear it up. Is it cleared up now?
Yes.
Definitely. Sounds good.
Okay. So I wanted to discuss a couple of things. The qualified immunity is one of them.
Yeah.
If you have a pen, I'm doing this by memory and it caught me off guard. I didn't know this was going to be live. I was hoping it was going to be, but I just want to throw out what I've got in my head.
Go ahead.
Professor William Dodd, and I'm not sure which law school he was from or with, but he did a document on qualified immunity and how it has actual law.
Correct.
True.
It is a conjured right that was, dreamed up.
Yes.
And so we need to abolish it. But the second thing I wanted to discuss is that the medical examiner has said that George Floyd didn't die from asphyxiation, but from
you know, why? Maybe Jerry will call back, but he's already given us two great thoughts. Do you know there's a case in Connecticut, Ed, where there was a fatal shooting, police involved fatal shooting of a man, and the medical examiner in Connecticut ruled it a suicide because the man acted in a way that forced the cop to shoot him. Did you know that? How is that possible that a medical examiner in Connecticut, when a police officer shot somebody, ruled that that's a suicide? And what Jerry just told us sounds very similar to that.
Well, let me.
Can we trust our medical examiners?
Hopefully, Jerry will call back.
Okay.
Okay. We apologize. This isn't CBS, NBC, or ABC.
Qualified immunity was conjured up in 1967 by the United States Supreme Court when they must have had a case. It was a sympathetic case with a police officer where they said, well, if he had good motives or if he had a good faith reason to do it. But then in 1982, Harlow versus Fitzgerald really set the stage for our modern day qualified immunity when it said, no.
What year?
1982. We're going to look at we're going to look at it from an objective point of view. We're not going to consider what the officer was thinking or not thinking. We're going to look at it like, would a reasonable officer in this officer's position have arguably acted the same way? Okay? And if the answer is yes, then that officer, even though he violated the Constitution, gets qualified immunity. So it all comes down to, did this officer act reasonably in an objective way? And you can conclude also from other case law that if there's case law on point that it was a violation of constitutional rights, whatever the officer did, then an objectively reasonable officer would not have done it. If there was something similar that had happened in the past, had been ruled a violation of constitutional rights, then you can assume that a reasonable officer would not have done it.
Summary judgment.
I'm sorry about that.
No, Jerry, I'm glad you called back. Can you listen for a minute and then we're going to let you come in?
Sure, that'd
All right.
be great. I'll put you on speaker and you just let me know when you're ready.
Okay, but you can listen on your computer, but it's delayed. Okay? But now Rachel's.
My situation is not going to allow me to sit inside with my computer if I'm holding on the phone with you, so I'll just be out here with the
No. Then I'm going to do the. You know something?
Qualified immunity.
Qualified immunity. It's your nickel, Jerry. Go ahead.
Okay, and really what I wanted to say on the qualified immunity is that there's no basis of constitutional law for it.
Absolutely.
So what we've got is a system that purports to have equal protection of laws and with no respect to classes, and yet you've got this class, this blue line class, and a black robe class that has exemption from accountability, and therefore the system that we expect to exist is gone and doesn't, and we have no recourse. The law has no remedy for us, and so that's what I wanted to say about qualified immunity. I don't know if you heard the part about Mr. Floyd being declared by the medical examiner to have
We did.
hypertension and some other things, and that puts him under the ADA, and the ADA is applicable in arrests under Tennessee versus Lane and City and County of San Francisco versus Sheehan.
Yeah, we're familiar.
Jerry.
I'm not a lawyer.
No.
I want to make sure I'm not speaking as a lawyer.
No, Jerry.
But I'm a
Where
certified Americans with Disabilities Act advocate.
where are you from?
From North Carolina originally. Right now I'm at large.
Are you in an RV traveling the country?
I am in a bus traveling the country. Yes,
Okay.
sir.
All right. Let me just add something to this conversation as we go forward.
Okay.
Number one, I don't give a shit whether Floyd had ADA, hypertension, or what. He died from a police officer's knee on his neck, on the ground, with nobody helping them.
Yeah, it's like they say, everybody dies from their heart stopping, right? But it's how we came to that point where their heart stopped.
Right.
Yeah.
Now let me.
I'm in total agreement.
Now let me explain. Rachel has had many cases, several cases, that have ended up with summary judgment decisions.
Or qualified immunity, right?
Some of which are now coming in front of the Supreme Court. It's just a different name, a different state, different lawyers.
Right.
But the issue is coming back. That's going to vindicate Rachel's case of 10 years ago.
Well, I just want to give you some hope, Jerry, and for the other listeners, and you may already know this, but there's been a push to get rid of qualified immunity. The Supreme Court has about 10 cases before it that are seeking cert to have this issue addressed. The Cato Institute has been pushing for it. Justice Thomas is behind it. I believe it's funny because it doesn't really matter what side you come from. Justice Thomas is for it. Justice Sotomayor is for it.
I think Gorsuch is for it.
Gorsuch is for it. So there are reasons from all ends of this political spectrum why qualified immunity should not be a doctrine anymore in our courts.
Now now that Rachel's got her nickel in, you got your nickel in, let me get a nickel in, see if we can come up to almost 15 cents. As far as I'm concerned, qualified immunity's out the window. A police officer does something wrong, it has to go to trial, it has to be decided, and there has to be a decision. Number one, if it's a decision that he violated somebody's constitutional rights, he goes on to what's known as the Brady list.
Well, I mean,
He goes on to a Brady list.
he's not an officer anymore.
But he goes on a Brady list so that if he comes back, these guys got fired. But there is at least one officer who went back to his department and retired while being on a Brady list.
Mm-hmm.
But that's neither here nor there.
Mm-mm.
What I'm saying is, this is the first time in my memory that I know of a police officer being fired by a department within days of an incident. Fired, outright fired.
Not only him, but the three others, I understand all
Right,
four
now
of them were.
sheriff's departments are totally different. They're political, usually the deputies are political appointees by the sheriff, but this is an organized police department, Minneapolis, Minnesota, and those people were fired. Now, the odds are, and the way the courts go, they may get their jobs back. They may get their jobs back. They're going to sue because their civil rights were violated, that they were punished without the opportunity.
Well, no. I mean, they're under a collective bargaining agreement. They're part of a union. They're going to get to grieve, go to arbitration. There's
Right.
ways to do that. Whether they will, in fact, do that or just walk away, who knows?
But what I'm saying is, the courts at the local level, like here in Connecticut, we have different geographical areas. They're basically county-based, but geographical areas. And the judge in his mind has to be going like this. But if I find against this guy, we're going to be one less trained police officer on the road.
Well, I think this case really is different. I think you're talking about the vast majority of cases, which again, we're going to get to it. The decisions in those cases are related to what happened in Minneapolis because the greater discretion you give officers, the more qualified immunity you give them, the less accountable they become. And when people become less accountable, they do things that they otherwise wouldn't do.
Well, because it was never decided. Well, because it was never decided before by a court, I have to grant summary judgment because they didn't know any better. But I'm not going to make the decision that starts the clock running and draws the line in the sand to say police officers cannot do this.
Okay, let's let Jerry. Go ahead, Jerry. Do you have anything else for us?
Again, it's Jay. I just want to
Oh, Jay, I'm sorry.
Okay.
Okay.
The thing that Rachel said about them having qualified immunity, the greatest degree of immunity, they have a great degree of immunity, and let's also remember that they are trained to minimum standards.
Yes.
So you have people out there with this blanket of absolute immunity. They're trained to minimum standards, and they get to engage their ego and their irrational emotional space of triggered sympathetic fear response, and they get to do things that they have no accountability for.
and they're taught about qualified immunity in the academy.
And I'm going to say something right now, because I'm also a First Amendment advocate. We have seen in the last month one or more videos, including this one, where video played a role in correcting the narrative of the police department. If there had not been video cameras on the scene in this incident, we would be talking about a whole different area of law. We'd be talking about a whole different set of scenarios, because they would deny doing what they did.
And any negative thing that George Floyd may have ever done in his life would be prominently displayed. It would be used to denigrate his humanity, provide an excuse for what happened.
The video showed other police officers standing around offering no assistance to a man who was handcuffed behind, or I should say restrained, probably with zip ties, behind his back. The video showed the offending police officer with his knee on Floyd's neck, with his left hand in his left pocket.
It's horrifying.
Okay? Now, the left hand in the left pocket would have probably never become an issue of the scenario and how it was going down, except for the fact there it is, living color with audio.
It just shows how there was no danger whatsoever to that officer, because when you're in danger, you do not put your hand in your pocket.
Oh, yeah.
Nobody does that.
Right. Yeah, I'd love for you to see my video, my latest video. I use a video camera as an auxiliary aid for disability.
Mm-hmm.
And I have PTSD from this. I have documentation out the wazoo, and some of it is even from state actors saying that city actors have perpetrated domestic violence upon myself and my family.
Right.
So, I mean, I've got the documentation, I've got the track record, and I use several methods to help slow my process down, including presenting the ADA as a claim on a pre-printed card, because I can't think clearly, and also a video in the incident. So, I've
Jay?
had some success with it, but I'd love to talk to you again sometime about that. I don't want to derail or steer your discussion in any direction you don't want to go.
And rest assured that that is an area of law that we're very interested in on this show. We, you know, I read a recent article by a scholar who is attempting to generate support for a theory that people can actually experience PTSD from the court process, you know, in family cases and what they go through. But the courts, as far as I know, don't accept that yet. I guess that would be hard for them to accept that they're yeah.
Jay?
Usually do accept it.
Jay?
Yes.
My name is Ed, E-D, Edward Delta, Peruta, P as in Peter, the country in South America, Peru, with Teton A Atom at the end of it. So that should be easy to remember. Ed Peruta at gmail.com. I would like, yep, Ed Peruta at gmail.com. Now, I would like you to make contact via Gmail email, and if you've got a topic you would like discussed or have an opportunity to discuss, send it in to us, and we'd be happy to give you some time to speak your piece. Do you have any social media accounts?
I've had several, because of my PTSD, I end up deleting things and just kind of trying to keep my head down. It's a fair walk. So,
Well, you
I
definitely.
will send you some information on my hand or whatever.
Jay, that's all we ask.
Yeah, thank you, Jay. You contributed a lot of good material to the show today. Thanks for
You did.
calling.
Thank you so much.
Okay.
Thank you for what you do. I didn't know this was really live, and you know, thank you for what you do. It's
Where
very
did,
important thing. I'm very
what YouTube channel are you watching us on?
News Now Houston,
Okay.
a prominent First Amendment advocate and auditor,
Yes.
and just a great all-around guy. News Now Houston.
You know why I'm on News Now Houston? Is Dave called me and said, how do I get started? And I told him, because I've been doing this for a long time. But listen, send us an email, make suggestions, make comments by email, and we'll check it and see if we can get your comments or your suggestions and work them into a show.
Thank you.
Thank you so much, Rachel. You have a good day.
All right.
You too. Bye. So yeah, I'm just raring to go on this subject matter, Ed. Okay, so what do I mean when I blame the courts for what happened last week in Minneapolis?
People, because of decisions called qualified immunity, government officials have not been held accountable for their actions. The minute the court comes down and says, like in Texas, Turner case, what happened was the court came down in the Turner case and said, you know,
Turner v. Driver, Fifth Circuit Court of Appeals.
They came down and they said, you know, we're going to grant summary judgment because prior to this incident, there was really no decisions to follow and the cops didn't know what to do and they thought they were doing the right thing. But here's what the court said. We're not going to give Mr. Turner any compensation. But from this day forward in this circuit, from this day forward, qualified immunity will not be granted for incidents like Turner's.
Because we now
We have established
that recording police activity is protected by the First Amendment.
Right. Now,
but I want to go deeper than that.
Go deeper.
I do want to go deeper than that because you're right. That is the one step behind what happened. But let's go even further than that. Why do we send kids to school, Ed?
because we need a babysitter.
No, I think it is to teach people from an early age that they need to conform and adapt to whatever propaganda is being taught at a particular era and time.
I agree.
Okay, and in my opinion, there's broadly three kinds of people. There's people who have no issue with adapting. They do well in school, and none of this is meant to be judgmental. I'm just saying
they're socially invisible to government. So they can conform, they can adapt, and they're never on government's radar.
They're taught that the police officer is your friend, and they believe it.
I was raised that way.
Okay, and I'm going to get to that because that's part of the problem too. Okay? The second kind of person is the person who cannot conform, cannot adapt. They're always getting in trouble. They're always asking questions, and
well, that's me too.
And usually they're ostracized to a certain extent. They're
I
maybe
was.
put in another kind of school. They're always getting in trouble.
I was.
Parents are always having it. But then there's a third kind of person. There's the person who has issues with conformity, has issues with adapting, but says, I got to play this game because that's how I'm going to get rewards. That's how I'm going to get a job and make lots of money. That's how I'm going to buy cars. That's how I'm going to go on trips. So I don't like conforming. I don't like adapting. I really don't believe that officers are our friends, but I got to play the game.
Play the game.
Because I don't want to be ostracized like that other group of people, right?
Play the game.
Now, Ed, who do you think out of those three broad groups of people become lawyers and ultimately judges?
The people who have played the game.
Absolutely. The people who know how to play the game. Now, some of them could be the people that have no issues and just adapt, but I'm going to say that most lawyers and judges are people who see issues but cover it up and play the game so they can get the rewards that society offers. Now, how does that impact lawyers? And most judges are lawyers. Some states are elected and they don't necessarily have to be. But most judges have been lawyers, have practiced as lawyers, have been to law school. So they are so invested in society as it is now. And what is society as it is now? We live behind a veneer that police officers are our saviors, that we need them to protect us, that we need them to keep us safe. What on earth would happen if we started believing that police officers are out to murder us, that police officers are out to rob us, that police officers are out to hurt us? Who the heck would you call when you have a problem? And somebody said that in reaction
Attila the Hun.
in reaction to the Indianapolis incident. They said, who do you call when the police officer is the murderer? And we talked about this, and I'll let you comment on it because I've been talking for a while, and then I'll get back to this. But imagine yourself at that scene in Indianapolis, and you see that police officer committing what you reasonably believe to be a murder.
What I would do? What I would have done?
Would you be justified in shooting that police officer to save that man's life?
Okay, that's the question.
Go ahead.
Elevated degrees of force to protect the individual up to and including deadly physical force. Now, let me explain.
I'm going to let you. I'm not going to butt in. Go ahead.
First of all, I want to go back to going to school conformity. I was in grammar school many, many years ago. And as a child, there were teachers I respected and adored, and there were teachers that I fucking hated. And to this day, I know their names of the teachers that I did not like. And I believe that in 7th and 8th grade, your National Honor Society candidates are already chosen.
I really want to talk about qualified.
We're going to get there. We're going to get there.
Okay.
Okay? Now, that's how you play the game. The people that play the game get on the National Honor Society.
And I don't mean that in a bad way.
No, listen. I'm standing on the side of the road and I see a police officer abusing a prisoner. I'm going to approach. I'm going to be very vocal. I'm going to say, you can't do this. I'm going to point to the other officers and say, you got to stop this. I'm not going to stand there with my camera silent. Not everybody was silent. You could hear people chanting, stop, 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 you can't do this, stop, 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 you can't do this. But sometimes the public chants and the public comments fall on deaf ears. In other words, what good is it to walk up to a police officer and say, I'm going to sue your ass?
None.
JC does it all the time.
They don't care.
JC does it all the time.
They don't care about being sued.
Okay? The one time that I said that and was proud of it was with Sean Spell and in Hartford when I said, I'm going to sue your ass, and it was a Friday, and they got sued on Monday. Thank you very much. Okay? But what I'm saying is, qualified immunity. I don't get any qualified immunity when I step forward.
But we're talking about, do you think that if someone had a permit to carry, and if you need one,
yes.
I would assume you need one.
Yes, I have a gun.
And
yes.
had a gun.
Yes.
Or maybe even if they didn't, but they had.
I'd be afraid. Would I be afraid to draw it down on that police officer?
What did it?
I know that there's 4 other police officers that are going to shoot me. I draw down on the one that's got the neck. I got 3 other guys with guns that are going to shoot me to protect their partner.
So that's a separate question. Justifiable versus fear for one's own life if you do it.
I take the Connecticut General Statute as a gospel. An individual has the right to use reasonable physical force to, and it used to be to arrest a fleeing felon, but that was Gardner v. Tennessee. A person has the right to use reasonable physical force up to and including deadly physical force to protect himself or a third party from expected bodily harm.
What if that man's mother or brother had been there at the scene? I don't know. Maybe they were, but I haven't heard that.
Well, I'll tell you what. It's you see the police officer's face on the video. I'd be living on some fucking island in the South Pacific someplace, okay? Because I don't think he's going to be safe walking around the city of Minneapolis.
But we're not focused on the one officer today. We're focused on what he represents is wrong with the system. And getting back to the example of who becomes judges, people that definitely have learned to conform, whether they have issues with conformity or not. People that have a large stake in the system.
Let me ask you a
and
question.
when you go to court, when an officer comes to a judge to get a warrant signed, when the judge, if the judge were to sit there and say, well, what if the officer's lying here? What if he's lying here? What if he's lying here? The whole system would fall apart because no warrants would ever get signed. They have to trust that the police officer is telling
narrative
the truth
of the officers
and putting in there what's pertinent and not leaving things out.
Let me ask everybody you a question. Everybody on the other side of the camera a question. We're all standing around and we're literally seeing a human being put to death by a police officer in our presence, and the person is restrained with some type of handcuffs or zip ties behind his back. What would have happened had the crowd charged the 4 police officers, grabbed the guy that did it by the back of the neck, ran over to a light pole, throw a rope over the pole, put a rope around that police officer's neck, and string him up and hang him right there in the street? Oh, the public is bad. The public shouldn't do that. Okay? But there is going to come a time when the citizens, if you don't correct this in qualified immunity, because now it's on the radar, the Supreme Court is either going to overturn it or support it.
The principle behind qualified immunity was this, because there's always 2 sides to a story, okay? And there must be a reason why we've had qualified immunity for this long, and this is why we have it. Because if you hold officers accountable for every little thing they do, if officers have to, before they take a step, say to themselves, does this violate the Constitution? Could I be sued for this? Oh, I'm not going to do it. Then the theory is that it's going to hurt the general public because police officers are going to be so fearful of being sued, cities and towns are going to be so fearful of being sued that officers are going to usually step back and not take the role of protecting people. So this is why qualified immunity came into being. Okay, we want officers to feel comfortable acting as any reasonable officer would act. So therefore, if there's no way he could have interpreted the law to say that it violates a person's constitutional rights because that previous case wasn't exactly like the situation that he was experiencing in this particular incident, then we're not going to hold him accountable. We're going to say you have qualified immunity. But like anything, the pendulum has swung too far now, and they're taking advantage of qualified immunity to be able to just step over that line and go where nobody could have pictured that they're going back in 1982.
You said in a lot of words what I was about to say in a few words. The courts have allowed law enforcement to cross the line without consequence on too many occasions. Even when situations are similar in nature. One happens in the 2nd Circuit, one happens in the 9th Circuit, one happens in the 5th Circuit, one happens in the 10th Circuit. They're the exact same incidents but for the names. Qualified immunity over here, qualified immunity over there, qualified immunity, and you sit there and say, the courts have, in one of those cases, I can't believe that they're all not able to go to trial. Let us make the decision on whether what the police officer did or didn't do was right or wrong.
Interesting point, Ed. Qualified immunity is an issue of law that in the courts only judges can decide. Judges decide issues of law. It's not an issue of fact. So a jury cannot decide on qualified immunity. If a judge decides the officers have qualified immunity, the jury never gets to see the case.
I've seen and heard of cases. I have friends in law enforcement. I had family in law enforcement. I've heard of cases, I've seen cases, where your heart goes out to the officer who found themselves involved in a situation, say similar to this, except there was a fight going on between someone who was absolutely, unequivocally evidence or probable cause to believe he committed a crime. He's being taken into custody and he's resisting. And he's winning the fight with the officer. And the officer shoots him. And then the family, who says, my son is the greatest kid in the world. He never had any problems. My poor boy was out there doing nothing. Goes after the police officer. I can understand where the courts go, you know, this guy goes to work every day. The police officer goes to work every day. And he's going to be threatened with a lawsuit. Every day he makes a decision. He's going to be threatened with a lawsuit.
That's where it
so we
came
have
from.
we have to create a line somewhere. Where is that line? Some people will sue over small things. Some people will sue over big things. Who's going to take the case? Well, nobody wants to, because it costs a fortune to bring a federal lawsuit to succession, to conclusion. Okay? So you can't find anybody to bring the lawsuit. And then if you find somebody to bring the lawsuit, government, knowing what the guy did, okay, that was wrong, puts the entire treasury of the local community, the state, or the federal government behind their law defense and runs you to death because you can't keep up with what they're doing. They're papering the wall to knock you down.
You know, there are prosecutors, and I would venture to say the vast majority of prosecutors, where if you're a defense attorney and you say anything negative about the police officer,
back of the bus,
like, oh, my client says the police officer took $3,000 out of his car, or my client says, you know how his face was bloody in the mugshot, that the police officer, used excessive force. They do not.
He fell down on the way to the cruiser and hit the thing.
Officers are heroes. Don't say anything bad about them, and that's exactly what's led to this problem. The way prosecutors and the courts look at officers like they can do no wrong, even when they do wrong.
My son Michael was standing in a parking lot questioning a sergeant sheriff in Indian River County, Florida. Rather than answer the question or deal with it, they placed my son under arrest, dragged him to the cruiser, slammed him into the cruiser. He actually lost the hearing aid, okay? And threw him in the cruiser, took him to the jail, put him on $500 bond. He had to pay a bondsman to get out of the jail, and he went to go to court because my son is going to go to court and tell the story. Charges dismissed. Charges were never filed.
He was lucky.
Right? Lucky.
Well,
now the sergeant has reason to do it again because he wasn't held accountable for what he did.
That's true.
That amounts to amounts to qualified immunity by the part of the prosecutor.
Right.
Okay? Now that sergeant, when my son says, no problem, I'll see you in court. No, you won't, because you're not going to go to court. But I got you out of the scene. I roughed you up because you questioned me. You know what I'm saying? You disobeyed my belief or my order.
Well, that's a good point. Yeah, you're right. He was not fortunate.
My nephew Nicholas was filming a building collapse.
Mm-hmm.
A firefighter from another town who came into the town said something, and the officer says, "You got to get out of here. You need to give some people some privacy." Okay.
Mm-hmm. Yeah. No, those are
so
all instances.
And it's not my first run-in with Sergeant Norman of the Rocky Hill, Connecticut Police Department. And so my nephew called me. I said, hand the phone to the sergeant. So he got on the phone. Oh, Ed, I didn't know who he was. See, then I talked to the fire chief who's in charge of the scene. He says, Nick came up to me, asked permission. I gave him permission to be there. Now, Sergeant Norman says, well, I was just doing what the firemen wanted. Okay? You stay away. Now, Sergeant Norman has not been sued. He has not gone to court for things like this. So he's going to keep doing it till the day he retires.
And he's going to be observed by younger officers who are going to learn that he did it and got away with it.
By osmosis.
And they're going to do it until the day they retire.
Well, my sergeant told me to do it this way, and his sergeant told him to do it that way, and his sergeant told him to do it that way, so that's the way we've always done it. Well, have you ever thought about reading the law? What? No, I'm just saying.
So why did...
I get very emotional over this because I believe that the government needs to start recognizing peaceful demonstrations and giving them credit for what they're doing.
I think you need to go to the source of why it's happening. And you brought up a point about your son Michael going to court and they dropped it. And I said, and I take the words back, that he was fortunate they dropped it. But when I said that, was what was in the back of my mind is some people go to court for that and they don't drop it. And they have to go to court.
Pay for a lawyer, lose days from your job. It costs you a small fortune to get a very brief summons to go to court.
Now, this time away from courts have been closed in Connecticut except for priority one matters, arraignments and domestic violence, restraining orders. You know, very few cases are being addressed in court, and those aren't even being addressed right in the courtroom. A lot of them are by video or whatever. And so many criminal defense attorneys are not busy now. They have a lot of time to think. They have a lot of time to think about what the courts do. They have a lot of time to talk to each other. And it's gratifying to know that other defense attorneys feel the same way and see the same things that you and I have mentioned for years. What if you're arrested and it's a bad search? It's a Fourth Amendment violation. There's a way to deal with that in court. It's called a motion to suppress. Suppress the evidence, you have no case against me. And what do...
A successful motion to suppress is followed by a motion to dismiss.
Right, because there's no evidence.
Right.
I mean, you and I had a case like that didn't
Right.
even get to the motion to suppress because the gentleman was charged with not having a pistol permit in Connecticut because he had traveled up from North Carolina, reported his gun stolen out of his car, and the police said, well, you don't have a Connecticut permit, so we're going to arrest you. And we went to court and said, where's the evidence?
That he had a gun.
Right.
Well, it was stolen. But you don't have any evidence that he had a gun.
You didn't catch him in possession of it. If I go to the police and say, well, anyway, I won't give examples, but they had to drop the case for lack of evidence.
See, that's a serious case where somebody's liberty is jeopardized by someone not thinking through what they're doing. Okay? And now, just to lighten it up, because I'll give you all the time after I tell this one short story. My brother Richard.
Well, I want to cry. I don't need all the time. It's a back and forth discussion.
No, I understand.
Right.
Listen, I have a younger brother, Rick. He's 10 years younger than me. I was 26 years old. He was 16. He was dating a girlfriend. On a nice spring day, him and the girlfriend got in the truck, his truck, and they drove down to the bank of the Connecticut River and were minding their own fucking business. They weren't having sex, they weren't smoking dope, they didn't smoke cigarettes. They're sitting there and there's a fishing pole resting against a tree with the line going out in the water. And a Connecticut Fish and Game officer comes up. I think I told you this story. Fish and Game officer comes up and says to my brother, he says, you got a fishing license? And my brother Rick says, no. He says, okay, reel it in. He writes him a ticket. He says, okay, reel it in. And he writes him a ticket. When my brother pulls the line in, there's no hook or bait on the end. It got hooked on a stone or a branch and came off. So the man gave him the ticket. Now, if it was me, I would have tore up the ticket and said, you win on this one. Got no evidence that you were fishing. Simply having a fishing pole with line in the water, without a hook and without bait, is you could be tickling the fish. Okay? My brother had to go to court in New Britain. And I went with him. And they knew who I was because I had been off the police department. But when I walked into the courthouse, they knew who I was. And I walked in with my brother, and I walked into the prosecutor's office. I said, why is my brother here? What do you mean? I said, read the report. I said, there's no hook and there's no bait referenced in the report because there was no hook and no bait on the end of the line. Charge dismissed. But why did my brother have to even take the time to drive to court to explain that when it should have ended on the banks of the Connecticut River. And this, Jesus Christ, 16, he's born in 58, 68. This is in the early 70s, in the mid 70s. Okay? Why? He's a kid minding his own business, fishing. Fishing game, got to get somebody.
Yeah, I don't know if that really relates to qualified immunity or not, though. I mean, that sounds like it's something where the officer could have been mistaken as to what the definition of fishing was. I mean, that's why that story's so interesting.
Sport fishing.
Yeah, that's why the story's interesting, because when you hear it, you say, oh, yeah, that is a good point or whatever.
Isn't there a case somewhere here in Connecticut? No, I'm sorry, it's in California, where I believe the Supreme Court is taking up a case where a law enforcement agency in California went into a house, seized some firearms because the husband had an issue, but seized the firearms that belonged to the wife.
Right.
And
yeah, we've talked about that.
They are not returning the firearms that belong to the wife. And it's gotten its way all the way up to the Supreme Court. And the Supreme Court has given the city until May 20th to respond. Now, in Connecticut, I'm willing to bet you there's been over 100 cases where law enforcement has gone into homes, not with exigent circumstances, but has gone into people's homes before they got the warrant, and then went to the judge to get the warrant to justify the seizure from the house. But there's one thing that I've said from day one. It has never been presented to or taken up by the United States Supreme Court or a federal jurisdiction, to my knowledge, to say, can you go in someone's house without a warrant? Now, here's what's going to happen. You sue because they went in without a warrant. And the judge says, grant of qualified immunity because the law is not established in this district, in this circuit. Law has not been established. Lets them go.
And to make matters worse, they don't take that occasion to establish the law.
Right.
They just say it hasn't been established.
You can end it right now. Make a decision. And now the law is clear. But you permit the law, judges and courts, permit the law to go undefined by the courts so that law enforcement's hands will not be tied. In other words, they can do it over and over and over again because there's never been a decision. Because of all of the qualified immunities that led up to what's happening today.
So, yeah, the law has to be clearly established at
Yeah.
the time the incident happened, and it has to be a violation of constitutional rights. So what courts most often do is they say, well, let's not get to whether it was a violation of constitutional rights or not. Let's just look and see if the law was clearly established. Oh, no, it wasn't clearly established, so case over. Done. And they don't
even though some aspects of the case, okay, deserve to go forward, the entire case, the baby's thrown out with the bathwater.
Well, let me clarify, though. I mean, you can have 5 or 6 counts or 30
Right.
or 40 counts
I
of a
understand
complaint,
that.
and some could be thrown out on qualified immunity, and some may remain.
Right.
So just because on one claim, qualified immunity attaches, each separate claim has to be reviewed for that. But you're right. Most times the case does go away. I have a case, Ed, and you know about this case, where officers, pursuant to a firearms risk warrant, in other words, they had the authority under the warrant to seize firearms and ammunition. That's it. Firearms and ammunition. Not even anything related to firearms and ammunition, not anything. That was it. Because under that statute, that's the only kind of warrant you can get to seize firearms and ammunition. The cops went in there.
You can't take a car.
They seized 2 cell phones. Now, we got the police report, and it appears that one cell phone was on the stoop outside the house. Okay, you could make the argument the client was under arrest, maybe it would have rained, the cell phone would have gotten ruined.
Found property.
They did it as a favor so it wouldn't get ruined, whatever. I could see that. I could see them easily getting away from that one.
Okay.
But one of the cell phones was in the house. how do you go in on a warrant that only allows you to take guns and ammunition, and you take a cell phone, which it's not any evidence in plain view of any crime?
I gotta tell you, in the case J.C. Playford had out in California, because he had his cell phone in his hand, they thought it was a weapon or a bomb detonator.
But there was no exigent circumstance because nobody was in the house when they were doing the search. No, I know, but this case is
now,
different.
Let me ask you a question, because I haven't kept up with that case, but I'm aware of it. Have they given the cell phones back?
No, I filed a criminal complaint with the chief of the department, basically saying your officer stole
2 cell phones.
Right. I focused on the one, but yeah, I did say 2.
And what does the chief say?
I want a criminal investigation. You know? Well, to be honest, we played phone tag a couple times. Okay, and then this whole coronavirus thing came or whatever, and so we're not going to court anyway. But I'm going to make a prediction. I'm going to make a prediction that the prosecutor's going to see nothing wrong with that, and that the chief's going to see nothing wrong with it, and nothing's going to happen to that officer.
And he's going to keep on doing it.
He's going to keep on just taking whatever he wants when he goes into a house, even if the warrant doesn't allow him to do so.
Well, I got to tell you, one of the qualified immunity cases that I guess was supposed to be considered by the Supreme Court didn't make it through committee. Okay.
Didn't get the 4 votes.
But it involved the documented theft by police officers of $225,000. So, qualified immunity was upheld in that case, and they're free to go and steal another $225,000. It's okay. I gotta tell you.
What is the definition of an objectively reasonable officer? How do you measure whether an officer's conduct is objectively reasonable? Qualified immunity depends on the objective reasonableness of an officer's conduct. I asked this question in the open carry cases that we did probably about 10 years ago now. And it was in front of Judge Underhill down in Bridgeport Court. And that was a case where he found that, I think this was, I can't remember if it was before Heller or in between Heller and McDonald. I think it was around that time, where he found that the law wasn't clearly established enough. And I said to him, well, can you make a decision
to clarify the law?
To clarify the law. And he said, maybe the Second Circuit will. And I understand that because he's district court. You know, in district court, really, they don't make the law. They kind of just follow the law.
What about the Superior Court judge? In a case where they went in without a warrant, and you raise the issue, and the judge says, take it up on appeal. I'm not going to make that decision. Take it up on appeal.
Right.
In several cases, that's happened.
Now, this is one thought I had in the Minneapolis case. Let's say he is tried for murder, whatever degree it is.
Third, they say.
Can he be convicted for murder, but still get qualified immunity in a civil case? It seems like that would be impossible, but that's one question I asked in the open carry. I said, what if an objectively reasonable officer breaks the law because all the other officers are doing it, so it's objectively reasonable for an officer to break the law because that's the code of conduct. That's what they do all the time. So if you're measuring police officers against each other, but they're all doing it wrong, does that mean you get qualified immunity because you're following the crowd and doing things wrong? But then if you're tried at a criminal court where you don't get such a favor as qualified immunity, you could still be convicted of the murder. There is a reason why the crowd around that officer last week did not try to do anything. I think the reason they didn't try to do anything was because they've seen this before. It's not an unusual thing for them to see.
The
Usually,
guy just happened to die.
yeah, the guy just happened to die.
He happened to die.
But this is business as usual.
It is business.
So
as
why are
usual.
you going to go out of your
Listen,
way?
listen to me. I think that we need to at least say this during the show.
Oh well, the show's almost over, right?
It is. This is what we need to say.
And
during the show.
I wish I could get to a couple other
Okay.
things. How about motions that are not heard
Well,
until
we-
time of
next
trial?
week.
Okay.
Okay. I want everybody to understand that Rachel and I spend a lot of time together during the week. I as her investigator, she as an attorney, and we have other things that we were kind of dabbling in. We have discussions driving in the car. We have discussions in her living room. She has discussions in my living room. And we both have unwavering support for law enforcement. But we don't support bad officers.
I guess that's how you define law enforcement.
Okay, listen.
That officer in Minneapolis was not enforcing the law.
You know something?
He was not a
And
law enforcement
unfortunately,
officer.
I don't think it was just a bad day for him.
Oh God, no.
I think that this was day in, day out. This is what they deal with.
And the chief of that department knew it, and everybody in that department knew what kind of guy he was.
Yep, and they got into his history. But what I'm saying is this: I can sit here at 71, and I can remember some of the things that I did that I now know were inappropriate when I was a police officer at 21, because I didn't know any better, or I was doing as I was ordered to do. Because there were times when I was a probationary officer that when somebody ordered me to do it, I looked them straight in the face and said, I ain't doing it. Find somebody else. And one time it was to the actual chief of police. I'm not going to tell the story.
Mm-hmm.
But I refused an order to issue a ticket, a summons, because the chief wanted me to. I handed him my ticket book. I said, you got a badge, you issue him the ticket.
But
my name's not going to be on it.
But those kind of people leave law enforcement.
I left.
They leave.
I'm gone.
They're either
I wasn't
terminated or
I wasn't
they leave.
a player.
Right.
Now,
You can't last.
so what I'm trying to say to you is this. The viewers to this show can't call into the show with the impression that we are anti-police, anti-law enforcement. We are not. But we don't like bad law enforcement, and we don't support bad police officers.
Well, I think the viewers can judge us by what they say. You
Well,
know, it's like when you tell somebody to trust you, I immediately can't trust that person. If somebody says trust me, I don't trust them. When somebody says I'm such a good person, I'm like, why are you saying that? Why do you need to say that? So whatever we say, people can take it for however they interpret it, okay?
I'm 71 years old.
But we don't need
and
to
I
defend
have a number
ourselves.
a number of people in law enforcement who respect me because I say it as it is. I call it as it is. But I got to tell the people in Minneapolis that are firing up the crowds, you're making a mistake when you start to burn down private businesses and loot. So, having said that, I think we're done.
We're done. Everybody have a good week.
See you next week.